In contrast to the fact, David Schwartz has clarified his stance on Twitter that the SEC's appeal is legitimate as the lawsuit isn't over yet, so they should have the right to appeal. However, for SEC this is an unusual case and the interlocutory appeal is the only way to speed up the year-long cases. This way, they can quickly solve the case by looking at different decisions made by different judges in one single attempt. Without interrupting the actual case, the court will only figure out what the defendants might have done wrong in one simple process. But Schwartz explained that it has to be dealt with due diligence, as they can make the already lengthy legal process even longer. Whereas according to Jeremy Hogan, a legal expert, this is legally a non-motion appealed by SEC. In response to the move, Ripple disagrees with this idea and thinks the main case, Ripple versus SEC, should keep going while the appeal is being dealt with. Many in the Bitcoin community also view Schwartz's statement as a response to speculation that the SEC may appeal Judge Torres' verdict to higher courts. However, one crypto analyst, Jack the Ripple, said there is absolutely no impact of the appeal on XRP. Despite some recent declines, XRP will soon touch the $10,000 figure and replace Bitcoin. Having said that, many think that SEC attacked XRP to slow down Ripple and let other companies develop their technology so that Ripple doesn't have a monopoly on cross-border payments. What next? From here on, if SEC's appeal is approved, there will be three possible scenarios. The first one is that if they appeal, it may impact the overall legal suit between Ripple versus SEC case. Second, if the court grants such appeals, it will give the impression that every small section of the case can be appealed, making the actual legal case lengthy and complicated. On the other hand, Fox Business journalist to XRP community, "Don't shoot the messenger." Gasparino says Judge Torres' ruling was not a huge win for XRP. Gasparino emphasized on August 16th that he doesn't offer financial advice, but merely reports on events. He highlighted his past accurate reports on the overvaluation of AMC and the failure of FNMA's pump due to Trump's decisions. Gasparino expressed skepticism about Judge Torres' recent ruling on Ripple's XRP, suggesting it wasn't the significant victory many investors thought it was. He mentioned that Judge Rakoff had echoed this sentiment. While Gasparino isn't sure about XRP's future, he advises caution to potential buyers, given the mixed court rulings. Furthermore, XRP bulls need this important move to spring to action. The broader digital currency ecosystem is wriggling out of the sustained bearish plunge that was recorded over the past 2 days. While the combined digital currency market capitalization is down by 1.16% to $1.05 trillion, the contributions of XRP to this downtrend as one of the leading altcoins is most notable. The coin has slipped by as much as 19% in the trailing 7-day period to 50 cents, per data from CoinMarketCap. The market slump of the past week has been encompassing, and XRP holders recorded a loss on almost all the gains. The positive XRP ruling of the past month has helped stir in the digital currency. With the current outlook, XRP bulls require a more defined trigger to retest the more than 70% growth rate recorded when the ruling went public. With the fate of XRP still very much intertwined with the lawsuit between Ripple Labs Incorporated and the United States Securities and Exchange Commission, the positive moves of the blockchain payments firm can go a long way toward fueling new growth triggers in the coin. With the SEC filing its appeal motion yesterday as directed by Judge Analisa Torres, the response from Ripple Labs will go a long way toward determining whether or not XRP bulls will activate their interest in stacking up the coin in the midterm. That the sales of XRP are investment contracts when traded on secondary marketplaces remains the bone of contention in the Ripple versus SEC case to date. Industry experts have noted that the affirmative ruling from Judge Torres has come to stay and that any form of appeal from the SEC will have no significant effect on how XRP is traded on exchanges. This solidifies the fate of XRP in the US and can spell a new era for the coin amid a broad-based listing from top crypto trading platforms in the country. Also, I would want to point out that MasterCard, a leading global payment processor, has showcased Ripple, the renowned digital payment platform, as its latest central bank digital currency partner. This association aligns with MasterCard's goal of tapping into the burgeoning interest in CBDCs that's evident among central banks globally. MasterCard's emphasis on CBDCs isn't random. There's a clear trajectory indicating CBDCs as potential frontrunners in shaping the future of finance. To solidify its role in this transformative process, MasterCard has launched its CBDC Partner Program. This initiative invites trailblazing entities in the CBDC realm to provide central banks with deeper insights into CBDCs, facilitating effective and informed implementations. Ripple has earned its spot as one of the 5 foundational partners in MasterCard's CBDC Partner Program. By being tagged as a CBDC platform by MasterCard, it reflects Ripple's relentless endeavors in the CBDC sector. A salient example is Ripple's recent introduction of its CBDC platform. Moreover, Ripple's fruitful alliance with the Republic of Palau, which led to the creation of the Palau stablecoin, currently undergoing testing, further attests to its capabilities. This collaboration signifies Ripple's potential to bring transformative CBDC solutions to the table. Anthony Welfare, a notable figure as CBDC advisor at Ripple, voiced his enthusiasm about the alliance, indicating a promising synergy between the two giants. Simultaneously, Michael Maybach, MasterCard's chief executive, emphasized the broader scope of the company's partnerships, suggesting collaborations with multiple central banks beyond its CBDC Partner Program members. Ripple, headquartered in San Francisco, is no novice in the CBDC territory. They've consistently expanded their footprint with meaningful associations and projects. Reports from earlier this year hinted at Ripple's readiness to dive deeper into the CBDC sector, which is anticipated to be worth a staggering $213 billion by the end of this decade. Their engagement with nations like Montenegro, Hong Kong, Colombia, and Bhutan for their respective CBDC initiatives is a testament to their commitment and prowess in this domain. The United States Securities and Exchange Commission has taken a significant step in its ongoing legal battle with Ripple Labs, requesting the U.S. District Court in the Southern District of New York to certify its interlocutory appeal. This move comes just a day after Judge Analisa Torres granted the agency permission to file the motion. The SEC's filing confirms its intention to focus on Judge Torres's ruling regarding Ripple's programmatic sales of XRP and other distributions. In her order on July 13th, Judge Torres determined that these transactions did not classify XRP as a security asset. The SEC believes that an immediate appeal is necessary due to the existence of controlling questions of law as to which there are substantial grounds for difference of opinion. One notable point raised by the SEC is the disagreement between Judge Torres and Judge Jed Rakoff, the overseer of the SEC versus Terra case. Judge Rakoff argued that the Howey test, which determines whether an investment qualifies as a security, does not differentiate between institutional and retail buyers. Moreover, the SEC expressed concerns that the court's ruling on Ripple's programmatic sales and other distributions could have a substantial impact on its ongoing litigations against prominent crypto exchanges, such as Coinbase and Binance. However, the SEC surprised many by acknowledging in its motion that digital assets, including XRP, are not inherently securities. The agency explicitly stated, the SEC does not seek appellate review of any holding relating to the fact that the underlying assets here are nothing but computer code with no inherent value. This admission has generated reactions from various crypto enthusiasts, who view it as a significant development. Prominent attorney John Deaton, representing over 75,000 XRP holders in the lawsuit, reacted to the SEC's concession. He emphasized the importance of having the judge explicitly acknowledge that the token itself is not a security, as this was the cornerstone of their argument in the brief. Ripple is expected to provide its response to the SEC's motion on September 1st, adding further anticipation to this high-stakes legal battle. Implications for the cryptocurrency market: the SEC's official acknowledgement that digital assets, including XRP, are not inherently securities marks a noteworthy shift in the regulatory landscape. This distinction could potentially have broader implications for the classification of other cryptocurrencies and their respective legal disputes. As the case unfolds, market participants eagerly await the outcome, which may shape the future regulatory framework surrounding digital assets. So we come to the end of this video. If you enjoyed it, like the video and don't forget to subscribe. This really helps me with the YouTube algorithm. Also share this video to as many people as possible. Let's get this news everywhere. If you are a true cryptocurrency fan, don't miss any of our content. See you tomorrow to talk about the latest news that concerns us all as a community.